Disney screwed over Ron DeSantis, the governor of Florida, publicly, and they used Meghan Markle's kid to do it. The type of people who take books away from kids are people who think they're smart enough. And in this situation, they were outthunk by some obscure rules. So what I want to do is go through some of those rules, talk about what happened, and talk about the legal outlook on what they chose to do. My name is Marcus Landsberg. Because this has Meghan Markle's kids in it, my kid is back here doing his Lego. But let's talk about what's going on. To start this, we have to go way back. Why did Disney open Disney World at Epcot Center in Florida in the first place? Why would they do it there? Disney was given what's called a sweetheart deal, the code word for when states want a business to open. Given that businesses, if that size, will provide jobs, tourism, money for the community, provide the infrastructure. Now, they've been butting heads with DeSantis, the governor of Florida. The big one that we all heard about was the quote-unquote Don't Say Gay bill. DeSantis was championing, and Disney said, we're not going to have anything to do with that. But now, currently, Disney is in negotiation to increase their minimum wage in Florida at $18 over 5 years. It means after 5 years, it will be $18. Anyone competitive in location 2, and that when you raise minimum wage, it raises all the other wages Disney would pay proportionally, because if you weren't getting minimum wage, you don't want minimum wage now that they've raised it for other people. Anyone competitive would also need to be, any other business would also be competitive with the wages that DeSantis supporters, business owners. It hits them directly in the pocketbook. So to understand what's going on here, we need to talk about Reedy Creek. What is Reedy Creek? Reedy Creek Improvement District functions like a county government. It takes care of things like roads, construction permits, fire services, building codes, water, waste collection, other infrastructure concerns. So this was Disney's sweetheart deal. They got to control Reedy Creek, so they wouldn't have to go through some local government to get their business plans, building plans okay. If you've ever been part of a small business organization, a small business, and tried to get plans, tried to do construction on your house, in many states, that's very, very hard to do. Sometimes it can be very expensive. What Disney was promised to some degree was no local oversight, because they would have control of the local oversight. This is pre-DeSantis. So DeSantis basically said, you know what? You've made it hard for me. You embarrassed me with this Don't Say Gay bill saying that you're out against it. So I'm going to make it hard for you. And he decided to replace the board of Reedy Creek with his own people, basically promising Disney all types of these procedural headaches in the future. You want a permit? You got to bring it to the board. You want to change the infrastructure, add an extra lane, build a new road. These are all things they could do very easily before. But if his people were in charge of the Reedy Creek Development District and they don't like Disney, they're going to give Disney a hard time, and it's going to be much harder for Disney to get these things done. So this happened. DeSantis appointed the board, and when they showed up, these newly appointed directors showed up for their first meeting. And on their first meeting, they were apprised that before they started, the directors who liked Disney, who were there right up until the day before, I guess, before the new directors started their terms, they had signed a contract with Disney before their terms expired. And this gave Disney the maximum control they could have under Reedy Creek over any project, any infrastructure issue that would happen in the Disney area. And this is all preface as to why the legal community is laughing at DeSantis. Okay, so what I'm going to tell you is this next section is going to be very, very legal. I'm going to talk about very much legalese. If you love that, you're going to love this. If you don't, I'm not mad at you if you fast forward to the next section. If you're studying for the bar, you have to listen to this closely. When you're studying for the bar, you have to study what's called the Rule Against Perpetuities. It's one of those things that the teacher laughs when they teach you because, I don't know why, man, you just have to know it for the bar. That's what they tell you. Perpetuity basically means forever. So the rule against perpetuity is a way to stop dead people from controlling land forever. Here's the rule. No interest is good unless it must vest, if at all, not later than 21 years after some life and being at the creation of the interest. Now, this version of the rule is from 1886, hence the sort of Old English type of language. But basically, a term of a contract on land, this refers to land, can run up to 21 years after the death of any person alive, at the time the contract is made. Any person alive who is designated at the time the contract is made. Historically, the term could conceivably run longer than 21 years. It would be void. Okay, have I lost you yet? Let's say I sell you land, but say if you or anyone you ever sell to, anyone in your family who inherits the land, gets arrested, that land either comes back to me or one of my heirs. Guess what? That clause is no good because it lasts forever, right? But if I choose a particular person and designate that no later than 21 years after the death of that person, and they are alive at the time we agree, then the term is good. Let me give you a more specific example. If the clause says, whatever it is, the land has to come back to me if some sort of term would occur, sell alcohol, become a YouTuber, any of that stuff. If it happens within 21 years after the death of your oldest son, and you have a son, that is a good term. That could stick with the clause of the contract. But if it is 21 years after the death of your youngest son, and it is conceivable that you may have yet another son, meaning after we sign the contract, but before you die, you may have another son. You may adopt, you may have a kid. Since you would have a son after the contract is signed, that would be the life of someone who is not in existence yet. Historically, that term would be no good. So I get it. This is the type of nonsense law that seems manipulative to people who don't have massive amounts of money, land, and access to lawyers. And I think it's important to remember, of course, that's who wrote the law. That's who it's designed to protect. Historically, the idea was to protect women or wives of rich people who may not otherwise be allowed to own property, and then any minor children who, if they were not alive at the time of the contract, would be at least 21 years after the death of their mother. Okay, so how does the king's grandchildren get involved in all this? And if you skipped ahead, welcome back. Disney put in what's called a, quote, royal lives clause. And what I'm going to tell you is that I never heard of this clause, as it is completely uncommon in the modern day. And for all the obvious reasons that you can imagine. But it's also completely legal. And the reason why we know it's legal is because it's been tried and tested in courts for literally hundreds of years. And that's the genius of the Royal Lives Clause that Disney decided to put in the contract. And it's also especially silly because it's going to be funny if DeSantis has to hire lawyers to argue the Royal Lives Clause. Enough preface. The clause reads, if the perpetual term of this declaration is deemed to violate the, quote, rule against perpetuities, quote, or any similar law or rule, this declaration shall continue in effect until 21 years after the death of the last survivor of the descendants of King Charles III, King of England, living as of the date of this declaration. So what do we have here? You have life in being occurring at the time of the agreement. So at the time of his agreement, King Charles III, who was the King of England, and he had a grandchild who was alive. So the last survivor of the descendants, in effect, till 21 years after the death of the last survivor descendant of Charles III, King of England, living. So whoever the descendant is, whoever's the youngest, who's ever living at the date of declaration. Okay, here we go. So why the King of England, besides the snarkiness of it? The reason why that they would use a royal lives clause is the royal family, and this is why historically it was very common, because royal family births and deaths are highly publicized. The announcements of a birth or a death is highly regulated. It's very rare, if ever, you're going to hear that a king has officially died and they hadn't died, or their descendant had officially died and they hadn't died. It was a fraud, or they moved on. So no prince is going to die without everyone knowing about it, and their birth and death will be highly publicized. There can never be an argument that someone has already died or that they went missing. We don't know where they are. So there's a suggestion. There's also the suggestion that some people suggest that if anyone is going to avoid an accident, it would be one of, if not the richest family in the world, who have their own private security and armed forces, who everybody's worried about and everyone's going to take care of and have all the eyes in the world on them. So Princess Lilibet of Sussex, Harry and Meghan's daughter, who, as I write this, is less than 2 years old. Disney World's growth and their control over the Reedy Creek Improvement District relies on you. Long may you live.